Hi there, everyone, and welcome to today's virtual roundtable, What's Going On with FLSA? This program is brought to you by ACUHO-I's Public Policy Advisory Committee, and we have some lovely guests from partner associations with us as well. You'll notice that this is meeting style, so you should see faces and be able to unmute yourself when prompted. I will pass this over to our chair and chair-elect of PPAC, Viktor Robinson and Vinnie Birkenmeyer in a moment, and they will give you instructions and do introductions. Thank you.
Hi, everybody. My name is Viktor Robinson. I serve as Director of Residence Life at Miami University in Oxford, Ohio, and the current chair of the Public Policy Advisory Committee. And I want to welcome you and thank you for participating in today's experience. Just to give you a bit of what we've been thinking about related to FLSA is that there's going to be three sessions. This is the first of three. This session is primarily designed as a primer, just to make sure that everyone understands what we're talking about when we talk about FLSA. If you're attending the conference, either the annual conference, ACUHO-I annual conference, either virtually or in person, there'll be other opportunities to engage in conversation, more roundtable type conversations at those experiences. So I'm going to ask today's panelists to introduce themselves. We have a mix of panelists that are they're from ACUHO-HR and the American Council on Education, as well as some practicing practitioners that have experience with FLSA previously, just to help provide some robustness around our conversation. So with that, I'll ask Vinnie, my chair-elect, to introduce himself, and then I'll ask the other presenters to introduce themselves as I call on them. Thanks, Vinnie, go ahead.
Hi, everyone. Vinnie Birkenmeyer, he, him, his pronouns. I'm the Director of Residential Life at Pace University in New York, and I'm the chair-elect, as Vika mentioned, so I get to work with and learn from Vika and the rest of our public policy advisory group, and you'll see me putting some information in there about our group, so if anyone's interested in joining other conversations after today that we put together, we definitely welcome that. So happy to see everyone.
Thanks, Vinnie. Brandon?
Hi, everyone. I'm Brandon Chandler, Director of Housing Facilities at Temple University in Philadelphia. And I am current president of ACUHO, which is one of our regional associations tied to ACUHO-I.
Thank you, Brandon. Jeremy?
Good afternoon. My name is Jeremy Sheffield. I am the Director of University Housing at the University of South Alabama in Mobile.
Thanks, Jeremy. Josh?
Thanks, Becca. Josh Ullman with ACUHO-HR. I've been Chief Government Relations Officer with ACUHO-HR since 2006, and I actually worked for the U.S. Chamber of Commerce on the 2004 rule, which we'll talk about in a little bit. So I've been doing this for a while.
Benny Gore.
Good afternoon, all. I'm Vinnie with the E, not Vinnie with an I. I serve as Senior Vice President for Student Life and Engagement, and it's nice to see a lot of familiar names and faces on here, so look forward to seeing in Pittsburgh.
And then Stephen.
Good afternoon, everyone. I'm Stephen Bloom, Assistant Vice President of Government Relations at the American Council on Education, umbrella org for traditional higher ed in the United States. And I've been here almost 15 years, worked with Josh a number of times on labor and policy issues, including this one, as we'll talk about in a minute, going back to the Obama administration.
Great. Well, thank you, everybody, for doing those introductions. So I'm going to turn it over to Josh and Stephen here in a moment. Stephen's going to screen share and walk through, just again, providing a primer on FLSA, just so that we can get everyone up to speed. I do invite you to put questions in the chat, and Vinnie's going to be monitoring the chat. And so we will, when it feels appropriate, do some of those questions maybe throughout the slides. But of course, once the slides are over, we'll have some opportunity for some question and answer and some community engagement. So with that, I will turn it over to Stephen and Josh.
Thank you. All right, let me see if I can do this. There we go. Hope everybody can see that. I do have one dog two dogs. Hopefully they won't make themselves known, but you know, it's possible you may hear a bark or two. Hopefully the mailman won't come, because that usually gets them very excited. In any event, as we mentioned a second ago, we're gonna Josh and I are gonna provide both a sort of a basic primer on the Fair Labor Standards Act, the FLSA, and some of the more kind of important aspects that are laid out in the regulations, as well as our advocacy efforts over the, really since the Obama administration, the Trump administration, and now what we likely anticipate potential changes from the Biden Department of Labor. Okay, first slide, hopefully you can see all of that. The FLSA, I'll just use the acronym. It's easier than Fair Labor Standards Act. It's an old law passed in 1938, really as part of FDR's New Deal, created the minimum wage and overtime requirements, as well as a number of aspects of employment, child labor law. And it has one of the more important pieces of it for our purposes, for your work, is sort of in the overtime area and exemptions to that. And there are the law establishes the executive, administrative, or professional overtime exemptions, EAP. We often call them the so-called white collar exemptions, which you might have heard about. And through regulation, the Department of Labor has sort of explained and defined aspects of the white collar exemptions. The key thing for you all to understand, and which will become clearer both as we talk about sort of the law and the implementing regulations, and then the proposals to change a piece of the regulations, is the test for qualifying for the white collar exemption. It's really a three-part test. One, are you paid on a salary? Two, is your salary at or above a weekly minimum? Right now, it's $684 per week, or $35,568 annually. And then are your duties, the so-called duties test? Really, it involves whether your job requires you to engage or utilize independent judgment and discretion as part of your responsibilities. In 2004, as Josh mentioned, the Department of Labor adjusted the regulations for the first time really since the 1970s, adjusting the threshold. Remember that three-part test: salary, the threshold level, and the duties test. They adjusted the salary threshold to $23,660, and they made some changes to the duties test. I won't go through in detail what those were. In 2014, the Obama administration, first President Obama, indicated by way sort of a memo that he was instructing the Department of Labor to update the regulations related to implementing the FLSA, particularly in the overtime area. And the department sort of moved forward with the process of issuing updated regulations. And Josh is going to go through in a minute the way in which we engage with that process and what some of the proposals were. And then they did issue in 2016, they issued a final rule that increased the overtime threshold from 23,660 to 47,476. You all, if you worked in higher ed at the time, you may remember that this was huge deal because it would require a number of changes in your world in terms of managing employees and who could be exempt or not exempt. And if they weren't exempt, they were covered by the overtime, the monitoring of their working hours. So Josh has just stepped away, but I will take the next slide. Oh, there he is. He's back. So this is his slide.
I apologize. I am shaking off a cold here, and I had to go get a cough drop. Stop coughing here. I apologize. as Stephen said, the Obama rule was issued. It also increased, not only did it set a minimum salary threshold that was relatively high from our perspective, it doubled the 2004 number. So that was a dramatic increase. But it also increased, set it so it would automatically increase every 3 years. This was a compromise position for the Obama administration, who had actually proposed automatic increases setting on an annualized basis. The problem we had with it as we kind of went back and forth is that this would lead to a couple of issues on campus, one being inflationary pressure up. This was particularly troubling for many of our state universities who operated on a fixed budget and didn't necessarily get inflationary adjustments every year with respect to their budgets. And then we also had issues of salary compression. And we felt that the acceleration at that pace of every year and even every 3 years would cause all sorts of problems with respect to kind of whether we were reclassifying folks every year, looking at new ways to change those jobs completely and restaff it because of budgetary concerns and just an overall paperwork burden of the changes and reevaluating every year. Ultimately, the Obama rule was struck down by a federal court. As Stephen said in the beginning, the statute set 3 categories for the exemptions, EAP, executive, administrative, and professional, and said the department has to define those terms, define and delineate those terms from time to time by regulation is what the statute says. And the court said, look, you can't just set a salary threshold. You couldn't set one. Actually, during oral argument during the case, what kind of went awry for the department on this was they were not able to kind of answer the question from the court, which was you couldn't set a salary threshold at 200,000, right? And just say everyone above that is exempt and below that. There has to be some way to define these terms other than just by salary. And the department really struggled with that question. And they said, didn't really say there was a limit to their authority to do this. And that caused them problems and ultimately resulted in the rule being knocked down. So what was our response during the whole process? Well, I mean, there were stakeholder meetings before the Obama administration issued their rule. And then there was a comment period after the proposed rule was issued. And then the rule went over to the Office and Management and Budget at the White House, where actually there were more meetings by higher ed than any individual stakeholder. I think it was close to over 50% of the meetings were done by higher ed stakeholders at the White House. So what was our concerns? Outlined here: increased labor cost, administrative burdens, tuition increases, the wide array of non-faculty employees that would be impacted, financial aid, residential life, at the time coaches, coaches were defined largely as teachers since then, and therefore don't have to comply with the salary threshold, which is one component. So doctors, lawyers, and teachers do not have to comply with the salary threshold component that Stephen described earlier. So they do have to meet the duties test, and they do have to be paid on a salary basis, but they don't need to meet the salary threshold, which is why we can have adjuncts paid on a per class basis, or we can have part-time faculty that works, and it's more of a struggle for others. But coaches, some of which have been defined as teachers since they're student affairs postdocs. We described situations where many of these professions, it doesn't work particularly well for them to be hourly. For example, with respect to coaches, we have these peak seasons for them where their hours get substantial. Sorry again. And then time later in the season where they may be working minimal amounts. We also talked about the loss of exempt status being moved from a salaried position to an hourly position, may be seen as a demotion. There's a lot of things you lose when you move to an hourly employee, a lot of opportunities for training, opportunities for travel, many other things, which again, don't necessarily lend themselves to an hourly rate. So going to a conference, for instance, and participating in everything in the conference doesn't necessarily lend itself to being an hourly employee, right? Well, you may attend some sessions, you may not. You're socializing, you're networking, you know, what's paid, what's not paid, and it becomes a complicated equation with respect to an hourly employee, overtime pay, and all those other things. And calculating that's difficult, if not impossible, for an employer to track. And these are the types of opportunities that when one is moved from an exempt status to non-exempt status, they may lose, and they may view the loss of those opportunities as a demotion. There's also some flexibility we'll talk about later that comes with it. Flexible work arrangements, part-time jobs. There's also some issues around remote work, which we're not sure how we're going to work out just now, but we'll talk about them towards the end. Go ahead, Stephen. So in 2019, after the rule was struck down, the Trump administration issued a new rule. Excuse me. With an increase of the salary threshold to $684 per week. Now, the threshold is always set on a weekly basis, but we annualize it for convenience. So that's why you always see it in a week form, and then parens in a salary in an annualized basis, because it actually is set on a weekly basis. And that's how the statute requires it. But it's at 35,600, so to speak, close to it right now. It was the same formula that was used in 2004 during the Bush administration to set the threshold then, just with the new numbers, the 2019 numbers. And that's how they came up with it. It went into effect on January 1st, 2020. We had asked for certain things to be included. They were not. Board, lodging, tuition, all sorts of stuff. These things were not included in the salary threshold, or not countable towards the salary threshold. There were no changes made to the duties test. Everyone had asked them not to touch that. You know, as was mentioned in the slides, the 2004 rule, there were substantial changes made to the duties test, and the result was substantial litigation on the back end for all sorts of employers, as the courts tried to sort out what these new terms meant, and no one really knew. There was always questions that the regulations hadn't specifically answered. These were answered, unfortunately, through litigation. And because the way the Fair Labor Standards is set up, where you're classified or you're not classified, it is very conducive to class action lawsuits, and actually has a collective action provision in it. So there was a lot of fear about liability and things like that. The longstanding exemption for faculty and administrative personnel was unchanged. There's a teacher exemption, as I said, to the salary threshold, and then there's an academic administrative personnel exemption and as well that's tied to the teaching exemption. It's a bit of a complicated formula, but it has to do with who's the lowest paid teacher there and how you can tie to that. We were able to extract from DOL, after all our meetings, some very favorable higher ed guidance. As I said, you know, the terms are hard to apply in real life sometimes. And the more the department can engage us and provide specific guidance in specific instances and scenarios, the more helpful it is to us. And we engage the department heavily to get some very specific higher ed guidance, which I encourage you all to look at. It's very easy to read. It's on DOL's website on the wage hour division. And that's pretty much it, the concerns that were raised there. Go ahead, Stephen, next slide. So, excuse me for a minute here. In the fall of 2021, DOL indicated in its biannual regulatory agenda, the Biden administration, every administration, issues a unified regulatory agenda once in the fall and once in the spring. The Biden administration's fall regulatory agenda came out in December. In it was a notice that they intended to change the regulations governing overtime in April of this year. At that point, Steve and I, familiar with this, and many others in the higher ed community, engaged the department and asked for some listening sessions and asked them to set up some meetings with higher ed beforehand. If the Biden administration moves, and they did that, and we've had listening sessions and whatnot, but if the Biden administration moves forward with the formula the Obama administration had, which we suspect they might, they didn't get it the last time, they may try to get it this time. They may kind of come up with better arguments as to why they do that. They may tweak the duties test along with it, but we suspect that that'll be the number. It would be somewhere in the low 50,000s. So 52, 53, somewhere in there. That said, there are certain members of Congress that have advocated increasing the threshold to 82,000 by 2026. So that would be a far more dramatic increase. I'm not sure what that would be immediately, but the request by several members of Congress was a very extreme increase. DOL has conducted, up until I think last week, several listening sessions with stakeholders. They had a specific one for higher ed, and then we had regional meetings. Higher ed, both Stephen's organization and many others, kind of representing the presidents, and then ACUHO-I met with the department through these stakeholder meetings. Sorry. And then we had colleges weigh in the regional meetings as well. We suspect that we're going to get a regulation sometime this fall. Go ahead to the next slide. And I will turn it back to Stephen, thankfully, for all of you who have to listen to my coughing. Sorry about that, folks.
We'll give Josh a break there. Hopefully he can, his voice will hold out. So I'm going to turn now to some of the pieces of the regulations that weren't really changed in this effort to update the overtime threshold that Josh just spent a fair amount of time talking about, and which is going to be really the most impactful kind of piece of this as we look at the Department of Labor's kind of expected new threshold under the Biden administration. Because, you know, remember, you have the three-part test: salary amount, the threshold, and your duties. And for many of you in the residential life world, we'll take out student RAs. You know, the key thing is going to be that salary threshold. So if your employees fall below that new threshold, they're going to have to be their hours will have to be tracked, and their if you don't want them incurring overtime, that's going to be part of the management of their hourly work time. And that's where it's going to be tricky, and some of the issues we're going to talk about in a second. So it's possible that that some of the employees in the residential life area may qualify for the administrative exemption under the duties test. The only challenge there is again, they have to demonstrate independent discretion and judgment, and that's very much of a, as we lawyers would say, a very fact-bound analysis. the challenge with it is that you're going to have to show that those employees are engaged in activity that's really related to the academic mission, the teaching component of the academic mission, that their duties involve something related to the academic kind of part of a college or university. I mean, we know that living on campus as part of residential life is part of a traditional residential institution, but that really wouldn't be sufficient for the administrative exemption. You really have to, in order to qualify for it, you have to be tied much more closely to the teaching or the pedagogy or advising about that. In any event, the other kind of piece in this is going to be sort of what is compensable time. We know that your people, say a director of a dorm, they're going to be, many instances where they're waiting to work, or they're engaged to wait, or they're waiting to be engaged. And, sort of, if they're on call, they're on duty, what is compensable and what are you going to have to track? And really the regulations sort of distinguish this in two ways. It's engaged to wait, which is considered work time and defined as a kind of work time, versus waiting to be engaged, which is not considered work time. And so those, the changes in the Trump administration and even the Obama administration, they didn't change this. These are longstanding components of the implementing regulations. It really is very fact bound. But the key point in the regulations, and I'll just, they're up there on the screen, for work time, engaged to wait, time is, is work, is considered work, even though the employee is allowed to leave the premises or the job site during periods of inactivity. So on a college campus, we know how that can be complicated because the work site it's not just the dorm, right? It may be broader than the dorm. But it really depends. The periods during which these occur are sort of unpredictable, and they're relatively short duration, versus somebody who's waiting to be engaged. They're effectively able to do what they want during their time, right? It belongs to them, they aren't really classified as being working. So the next sort of key background, actually, I wanted to give you one example that I had here, and I'll go back on this distinction between engaged to wait versus waiting to be engaged. And it's laid out, referenced in some of the fact sheets that the Wage and Hour Division at the Department of Labor put out. Residence hall director, let's say they're a graduate student and they work in the morning for say 3 hours on duties related to their job. They're planning activities, they're conducting or attending meetings, or they're doing other administrative duties, and then they go off to class at the university and then return home to study, watch television, do their laundry or whatever before resuming their duties for about 2 hours in the evening. Under this framework of engaged to wait or waiting to be engaged, the employee has only really worked 5 hours there. And so the hours spent actually engaged in performing duties of the residence hall director, those are the ones that are deemed to be compensable and which are going to need to be tracked. So a couple other, we've got really 3 more key issues, and Josh will talk about the last one. So meal times or meal periods. A bona fide meal period is, where you have a clean break between your work and actually eating, and going into a cafeteria on campus to eat. Let's say even if a student comes up to the student in the dorm comes up to a residence hall director and asks a question or something, if it's very minimal, that period when they're engaged in a bona fide meal and meal break, that will not be counted towards their compensation or their time to calculate their compensation. But it has to be a real meal, not like a coffee break or snacking or something like that. And the other piece, because many of your employees, certainly those like in the dorms themselves, they're sleeping there, right? And so the regulations talk about this, and not surprisingly, there are other examples of employees, say firefighters, who sleep in their workplace when they're and really the way the regs sort of parse this out is if it's less than a 24-hour duty, you're considered working even though permitted to sleep or engage in other personal activities while you're not busy. And it doesn't really make a difference that the employer furnishes the sleeping facilities. If you're required to be on duty and the time, so that time has to be counted as work time. But if your duty is for 24 hours or 24 hours, not sure how you can have more than 24 hours at time. I guess so. You could more days than one day. And you've agreed to exclude sort of bona fide meal periods and regularly scheduled sleeping periods of not more than 8 hours, you can credit a maximum of 8 hours for sleep against their hours. And then, the regulations and some of the other supporting documents talk about if your sleep is interrupted. Let's say it's this 24-hour duty period, and your sleep's interrupted, like there's an emergency or a student comes to you in the middle of the night, for some reason, and you have to get up. As long as I think it's like they say a minimum of 5 hours sleep, they will consider that sufficient to be able to attribute a total of 8 hours of sleep that can be excluded from the 40-hour calculation. I'm going to turn it back over to Josh to finish up.
Thanks, Stephen. So one of the big issues that has always been discussed around moving from salary to non-exempt or hourly is this issue of remote work. Now, obviously, during the pandemic, many of us managed unusual situations with respect to remote work. I know a lot of employers allowed hourly employees to go on to remote work, and that is something that's fairly new. Part of it is the statute, which says employers are not allowed to have to suffer or permit the workers to work. Otherwise, they have to compensate them. So it's this suffer or permit, and not permitting a worker to work is complicated with respect to remote work. You have to draw some very sharp parameters around it, and there's always been fear of liability. As I mentioned before, the statute itself lends itself to class actions when there's been mistakes on classification, or there's a failure to report, or there's a process that leads to a failure to report. Employers are responsible for recording hours, period, of hourly employees, and they need to record them accurately. And any indication that they're not, whether a failure in policy or a failure of implementation of a policy, lends itself to litigation. Now, during the COVID pandemic, I think both employers and employees and plaintiffs' lawyers and everyone involved decided not to test the FLSA boundaries with respect to this because we had enough going on, right? I think the problem is on the back end of the pandemic, we are probably 2 good class actions away from every labor and employment law firm in the country telling their employers hourly employees can't work remotely. And that's what I fear, is that we will see 1 or 2 class action suits where the numbers are very high and general counsels and risk management say, and insurers, which insure against this stuff, say you can't have hourly workers work remotely in many circumstances. So that's kind of what we're looking at as the map there with respect to this remote work and how we manage it moving forward. It's a little unclear, but I am in the camp that I think litigation will inevitably occur here, and there'll be some parameters drawn on it. But I think it's not going to be normal. We've done a lot, so we're high as far as hourly workers being allowed to work remotely. I think we'll see litigation. There'll be panic, and that'll drop. And then as the litigation sorts itself out, and we kind of understand where the parameters are, we'll level set again. And there'll be some parameters on how you can manage this through technology and whatnot. And it'll lend itself to certain jobs, but probably not others. So that's what I think is probably going to develop with respect to this. But that is a huge issue as we move into setting the salary threshold high and possibly reclassifying folks. And with that, I guess we'll open it up to questions.
Well, thank you both so much for going through on that information with us all. I do invite our participants today to submit any questions that you have to the chat. What I'm going to ask of our practitioners on the line of Vinnie Gore, Brandon Chandler, and Jeremy Sheffield is if you could just recall sort of to 2016, and maybe you were all in the same role you're in now, or maybe you were in slightly different roles, but can you talk a little bit about your experience as a practitioner around what you can recall the last time that this came up and it was a big deal, which was, of course, when we were looking at changing the threshold from 23,000 to 47,000. So I don't know if anyone wants to go first, but looks like Vinny's unmuted. So if you want to go ahead and talk a little bit about your experience.
Sure, Vika. So Michigan State's a large public institution. We have 11 different labor groups in which our live-in staff is in a labor group, which may be unusual for other places. So I just wanted to sort of put that within context. So we, like I think most public institutions, needed to do analysis about who was within the regulations and what roles were they. And so as we began to take a look at that, it meant adjusting our salaries for our live-in staff, which created compression for some of our other staff, including facilities. So, within the group, so we needed to, it had some collateral implications across the organization. And so which required us to do a little bit of a salary study based on the levels. For an example, we had supervisors who were considered non-exempt, which meant they would get overtime and working. Our live-in staff wasn't. And so the salary levels needed to reflect the difference of that. So there were some budget issues that we needed to think through. We did make the decision to increase the live-in staff, and then we backed down, and then we increased it since now we're, as everyone on this call will know, we're in a competitive market trying to hire live-in staff. So that has, we're exceeding that threshold as if it was in 2016. So I'll let Brandon and Jeremy sort of share their thoughts.
Sure. I think my most poignant reminder of this conversation back in 2016 was we were gathered for a NASPA Region 2 conference in New York about the same time this dropped into the frying pan then. And there were a lot of senior leaders kind of huddled in rooms like, oh my God, what are we going to do? I think one of the most poignant things was there was a clear line in the sand between the publics and the privates, and the large and the small. And I think, that same panic will play out again, that larger schools seem to be closer to the $47,000 or $45,000 mark, wherever it was in 2016, that we were trying to hit to try and not have to make these decisions. A lot of the public schools seemed like they were just going to add a couple $1,000s to the pot and pretend like the salary compression really wasn't there. And the privates were kind of losing their mind, and the small schools and the Catholic schools were really kind of like, I don't know how we're going to do this. I imagine this will probably just refresh that whole thing all over again. I think one of the things that we were talking about at the time, which is again where we're at, is, and now we're after COVID, is this is really an opportunity, I think, for, if it comes along, for a lot of us to really, examine our housing programs or other campus programs, and really, really consider, can we do this differently? And it's not going to be an easy, this is not a 4-person in a small room for a couple of weeks, come up with a new plan for how to run campus housing. But really, really peel things apart and decide what you must do and what can be given back to people that we've kind of attracted to ourselves over the years, and what might need to just die. And I think COVID has taught us that we inherited some things that we just tried to get it done, and we really want to give those things back because a lot of people are burnt out trying to manage people's health and their safety and their happiness and their well-being all at the same time. But I think this gives us an opportunity from the outside of higher ed to say, is this how we should be really doing this? Is there something that we could be doing differently and better? I know one of the other things that we were talking about at the time then in 2016 was, back to, I think it was one of the slides that Stephen had, is, do we really need to have hall directors live on campus? How many of them, which types of people? Like, there was a big consternation about the fact that the housing costs were not included in the salary. And I know for a lot of schools, that's a part of what they consider to be the package. But the thought occurred to some folks is, do we actually need them to live on campus? If they live close enough, can they return to campus like other departments do to respond to an issue? That answer will be different for different schools depending upon your location and your setup. Whether you have campus police or campus security versus community policing and community security. But there were just lots of different ideas on, do we really need to do this the same way? And is the government really telling us that we really should be looking at it in a deeper, harder way?
I agree with quite a bit of what Brandon mentioned. In 2016, I was at a small public institution in a very rural area, and we were having numerous discussions about the much lower cost of living and how this would more significantly impact us compared to maybe a larger institution in a metropolitan area. Our big concern was, one, the timing, how quick the change was projected to occur, and how we were operating on a fixed budget and not anticipating any increase in funding or increases in enrollment. And I think we're going to be having those same discussions here in the next 2-3 years. Across the nation, I don't think we're going to see that big of a jump in enrollment, that big of a jump in additional funding from our state legislatures. Really, it's going to become more hard-nosed, looking at budgets and figuring out what are the priorities. And I do think that rethinking how university housing and residence life operates might be the deciding factor for many directors as they're trying to decide what they want to allocate their resources to and best serve their students.
Thank you all. So I don't really have a question for him, so forgive me while I find the words. So there's, what struck me in today's presentation was this idea around judgment and independent decision-making related to the duties. So that's a duties element. And I hear us having conversations about, are we looking at what they're doing and giving things back and salary adjustments. But I guess I'm having a hard time thinking about the removal of independent work and judgment. I don't know how that goes away in our field, but maybe there's a perspective out there that it might, because I feel like, and correct me if I'm wrong, Stephen or Josh, I feel like if that continues to be a component of the work, they're still going to need, like, we're still going to need to account for the salary difference. Am I understanding that correctly?
No, I mean, you can be hourly and have independent judgment. I mean, an employer can choose to pay you hourly no matter what. They can just say, you know what, I'm going to pay you hourly. You're going to be hourly. There's a lot of kind of constraints that go with that for the employer. And then there's a lot of constraints that go with that with the employee. I mean, it's very hard to attract professional employees who want flexibility, who want career development opportunities, who want to be autonomous with an hourly status. So it's often about the recruitment, but you can take someone who has independent judgment and just say, you're going to have independent judgment, but the reality here is we're going to pay you hourly. I mean, they can do that. It just doesn't happen because it's very hard to attract people who are professionals that want to operate on an hourly basis. It's, particularly early career professionals, as I said, want the opportunity to advance and move forward. And they may see that, as something that would be limiting.
Josh or Stephen, I was curious if you could, I was listening when you said the one way to deal with the duties test was to kind of focus on the connection to the academic pedagogy of the university. And I'm curious, for our campus leaders or campus programs that have these living learning communities or academic themes that are built into our programs, to what extent that the staff that are deeply involved in those communities that are putting together the educational content for those students that are in those communities, does that give them some leverage into that conversation about whether they cross that line or not?
So that is, and I'll let Stephen get into it more because he covered that, but there's this, so we have the teaching exemption from the salary requirement, and then there's this academic professional exemption, which is sort of tied to the teaching exemption. It is not well defined. And as I said, the terms are always difficult to apply in the specifics, and particularly in the absence of really good guidance in litigation. And it has not been a exemption, a portion of the exemptions that has been well fleshed out. Stephen, do you have other thoughts on that?
Yeah, I mean, I'm looking at some of the material from the Department of Labor. They talk about it as, say, somebody who has an academic counseling role as part of their duties. So they assist students with their academic problems, or they advise students concerning degree requirements. So the fact that, say, a residential hall director runs programs that we might argue are part of the academic experience, I'm not sure that would be sufficient, because they're kind of supplements to the academic environment. They aren't, tightly connected to the degree that a student is enrolled in and what they need to the classes they need to take and the number of hours, et cetera, and their coursework. I think that's probably the way the Department of Labor would look at it. But, as Josh said, it's not well defined. It's very fact bound. And, one thing to keep in mind on all of this, which we didn't say, but it is really important, job title doesn't matter, right? It's really about the nature of your duties and whether they involve this independent discretion and judgment. And that isn't that well defined, but it is laid out in the regulations. And that is actually where, as Josh mentioned, lots of litigation, that's where it arises. Is somebody engaged in, do they use independent judgment and discretion as part of their job?
And a lot of it, that's perfect, Stephen, on all of it. But a lot of it also goes down to, in that exemption, how much do they do this task that you're talking about? How often, how much of their time, work time, is dedicated to that? So, okay, let's say I do a little bit of this or that. And that's why it gets so difficult, because higher ed, even if we have similar job titles, we have vastly different duties and approaches across the same job from one university to another, often from one department to another. And that does make it tough. So the examples you're talking about, it's just, it would depend how much they're doing it. And as Stephen says, the real nature of what they're doing. and it gets into kind of a very granular analysis of those duties.
Thank you all for answering those questions, and thank you, Brandon, for asking that question. There's a question from the chat. I'm gonna, Max, if you want to unmute and ask your question to the group, that'd be great.
Certainly. So my previous institution often related the FLSA question and hall directors to almost building supers. When that a couple years ago, whenever we were all talking about that, and that's how they almost equated it to. And then we didn't do the whole bump up because, like many others have said, we were a small private. I am now at a different institution, and I'm just kind of going back to that idea of what happens in my new role when I now have my staff asking me, what are we going to do? Because I actually have no idea, because and I think that's a lot of where everyone is kind of sitting at this moment, is we have these intentional conversations, we have all of this academic input, but we don't really know. And I think the other piece of it for us, me, in my previous institution, was they classified housing as a part of your paycheck. And I'm really trying to figure out where that comes into play specifically, and if that is even a part of FLSA or any part of this conversation.
Stephen, you want to take it, or?
Yeah, I mean, and Josh, you can, I'm looking at the regs. They specifically exclude board, lodging, and other facilities. Other facilities are like, meal, kind of services, or like going to a cafeteria. If the food at the cafeteria is kind of part of the compensation, the package for somebody, say a dorm director or something, that's not it. That will not count towards your salary threshold, right, Josh?
Yeah, I mean, they're just, it's not factored in.
Right.
But you squeeze on these balloons enough, the issue is when they reset the salary threshold, there's a certain group of people who are like, oh, everyone's going to get paid more. And, those of us who are in it are like, and it forces conversations on whether some of the things need to be eliminated and how to do these jobs in a different environment. But it doesn't necessarily mean that certain people are going to get paid more unless it's a small bump. And then that tends to happen. And then compression becomes an issue, and maybe other people get bumps. And it's capable. When we look at large scale changes, it often evaluates, how do we do things? Do we provide room and board anymore if it doesn't do that? And do you have to live in the dorm, as someone says, or do they just say, here's your money and here's kind of where you can live within a certain radius, and that becomes it. And they use the housing for other things. It'll be interesting to see how that's handled, but always these things involve a set budget and how you staff things across that budget. And there may be changes you can make to that budget, but they're not going to be allow for doubling salaries or vast increases. Residence directors are probably not going to be getting room and board and making it low 80s in 2026, right out of college. I don't see that happening. Maybe I'm wrong, but there'll be some other approach to address the situation. If the threshold's bumped up that much, some of them may be hourly, some of them may make a lot more and make it up to 86. I doubt those will be the ones right out of college. But, then there'll be just different ways things are staffed. And that's kind of always the way we see these things develop, which is, people need to operate within the framework of their budgets, and then they kind of look at how they staff it from there. And that changes things fundamentally. Sometimes it's good because everyone needs to reevaluate things and make sure that people are fairly compensated and people aren't taken advantage of. But it doesn't mean that we can wholesale change the economy by just resetting that salary threshold.
So
So
one
my
other, go ahead, Max, I'm sorry.
Yeah, I guess my follow-up question to that is, for someone who doesn't know policy and public policy specifically well, I'm an operations person and I recognize that. Where is there a easy readable guide on FLSA that I could read that are the current regulations?
The department does put out some decent stuff, and the higher ed
Yeah.
guidance is very good. They worked at it. The problem is these things are, it is the overlap between rules, which are general, and unique situations, which are particularly poignant in higher ed. As I said, every business does things different, generally, but every higher ed institution does things really different. We tend to not have kind of the same consistency and gravitate towards certain things because we have unique pressures on campus. We offer very unique products often, and including the environment and everything else. And it's supposed to be a tailored environment. And because of that, the jobs are often very tailored. And that does make applying general rules to specific instances even more challenging in higher ed than it is elsewhere.
Yeah, I would just briefly just second what Josh says. The Department of Labor, the Wage and Hour Division, I'm actually looking at, I used it in my preparation today, a fact sheet that is specific to higher education. And and it is plain language. I mean, the regs aren't, but the fact sheet is.
Can you put the link in the chat?
Yeah, I can. I will. If I can't find it now, we'll give it to Vika, and we'll make sure it gets distributed to all of you. And in 2016, if passed as prologue, the Department of Labor put out like a longer document for higher education that went through and discussed the implications for higher education, and it was plain language. You could read it. It was much longer than the fact sheet, but it could, it would give you some a deeper sense of how it would play out for you and your campus. And I suspect they would do that again.
Well, that was a very fast hour. Thank you to everyone who participated in the conversation. As a note, yes, Stephen, if you want to send me that link, I can also try to find it myself. But if you want to send me that, what I'll do is I'm going to put that in the Public Policy Advisory Council online community. So if you're interested in that particular thing, we can do that, and we can also work with the central office to get that link to people who registered for today's session. Remember that this is a part of a continued conversation. So this is part one of a continued conversation. There's going to be an opportunity to dialogue more about this information at the annual conference and in person, as well as the virtual one. And for those of you who are unable to attend, you can count on us to have continued conversation available in this kind of medium as well in the future. I want to encourage everybody to start having these conversations right now on their campus. Some of you might be like, I don't have the power on my campus to make these decisions, and that's fine. This is a conversation that everyone should be thinking about and talking about on their campuses. And so it's certainly, every campus has different things, different policies and procedures and ways of doing things. Your general counsel, if you have a general counsel, is probably already having some of these conversations. If they're not, talk to your director or your VP or whoever to start to say, hey, like I was in this session today and I heard about FLSA. Do you know if we're having these conversations on our campus? The time to start having these conversations on your campus is right now. What happened in 2016 is people didn't think this was going to happen. And then it did. And then everybody was like, what? You didn't tell us. The time is right now. So FLSA is designed to do good in the world and to do good in our country and to make sure that people have a living wage. And it can feel when you're a decision maker that, oh my goodness, why is the government doing this to higher ed? Why is the government doing this to housing? And the reality is that we are a piece of a lot of pieces. And FLSA is designed to make sure that people have a living wage. And that's a good thing. It's a good thing to evaluate what people are making so that they can have a living wage, and as I like to say, and have a thriving life. And so it's a lot to manage and to be a decision maker around, to be a leader around, but it's a good thing to make sure that we're doing what we need to do to provide a living wage for folks that work in our organization. So thank you again for your participation today. Again, this will be a continued conversation. To my panelists, what happens when this ends is that we just all go away. So I don't have another opportunity to say thank you for your time today. So thank you for your time today, and thank you for our participants. And with that, I will close our time together.
Thank you very much.